Hello and welcome to the Administrator General and you. I'm Nadine McLeod. You know, many Jamaicans are afraid to write a will because they believe that as soon as they write a will, they will die. But writing a will is a part of estate planning. And that's what we're going to talk about today. With me are Mrs. Sharon Brooks Hilton, who's an insurance consultant, and Mrs. Alia Leith Palmer, who is the acting senior legal executive at the Administrator General's Department. We'll begin with you, Mrs. Leith Palmer. Tell us a little bit about estate planning. What is estate planning?
So estate planning is the process by which an individual would put plans in place to take care of his assets after death. This could include the preparation of a will or the preparation of trust documents, a trust deed. It is a part of looking at your asset holding. So it could also take into consideration how you treat your credit cards, your loans, your insurance policies. Do you have beneficiaries named on those policies? So it is for the individual to take into consideration all the asset that he or she owns and how you'd want them to be dealt with after death and put plans in place for those things to be done.
You spoke a little bit about will as a part of estate planning.
Yes.
People are usually asking, how do you write a will? Can you just write, I leave my dress to my daughter, and that is valid?
No, there is a requirement under our Wills Act for certain things to be in place for a valid will to be created. So it has to be in writing. It has to be signed by the testator at the foot and witnessed. And for it to be witnessed, then the testator must sign in the presence of his two witnesses or acknowledge his signature in the presence of these two witnesses.
Who is a testator?
The testator is the individual who is making the will. And the testator must be 18 years or older. He must have a sound mind and be clear about what he or she is doing. He must approve of the contents of the will as well. So it doesn't have to take a particular form, but there are will forms available at most pharmacies. It's available on the Administrator General's website, and it also comes with instructions, the one that we have on our website. So those are the formalities that you'd have to take into account. It must also be dated.
Mrs. Leith Palmer, let's say John Brown is writing a will. What should be at the top? Take us through writing a will.
Okay, so he would need to put his name, his full name, not an alias.
So he would say, I, John Brown.
I, John Brown, give his address. He would revoke all previous wills and testamentary disposition. That is just in case a will was made before and he wants this will to replace that one. Then you normally have a revocation clause at the top. He would then appoint his executor or executors. These are the persons who are responsible for carrying out the wishes of the testator as stated in the will and ensuring that it is probated and effect is given to the document. Then he would include a residuary clause, which is oftentimes left out, to deal with assets that might come into the testator's possession after the will is created, or there might be assets coming to the testator that he or she is not even aware of, from somebody else's will possibly. And that residuary clause will address those assets. The testator would indicate who is to benefit from his residue. And of course, again, he signs, dates, and have his witness sign as well.
You know, oftentimes people say they don't have anything to put in a will. Maybe they don't own a house. Maybe they don't own a car. Can anybody make a will? Let's say I only have clothes alone or shoes. Can I also make a will?
Of course. Once you begin to accumulate assets, clothes, shoes, you know, it's amazing. When persons die, you don't know what happened, of course, but it's just amazing how many persons fight over what you have left behind. No matter how insignificant you might have thought it to be, there are persons who value these things. So once you begin to accumulate assets, I believe that is the time you begin to assess whether or not you should be preparing a will or taking steps as to other means of estate planning.
I'm sure sometimes people would make mistakes when writing a will. What are some of the common mistakes that you see Jamaicans make when they write wills?
I would say that oftentimes they leave out the residuary clause, which means that you die partial intestate because the will doesn't cover assets that would fall to you after you have made the will. So the exclusion of the residuary clause will be one.
And before you go any further, Mrs. Leith Palmer, what is a residuary clause?
So the residuary clause is the clause that comes after you would have dealt with all the gifts specifically that you're dealing with. Is a clause that says, I leave all the rest of my residue and property or estate or everything else I leave to.
So that accounts for everything,
for everything else
that you would forget and... Okay.
That is so. So anything that is not specifically mentioned in the body of the will, this clause captures everything else. And you normally indicate to whom these assets are to go to.
And this could be like NHT refund?
NHT refund, unpaid salary from your employers. Vacation leave entitlement. It could be that somebody else wanted to leave a house to you and you didn't know. And so that house now falls to your estate, but you would not have provided for it in the will, that section that you'd have made specific gifts. And so it is important for that clause to be included so that you are not partial intestate. And then what will happen if that clause is left out and there are assets, then those assets will be dealt with pursuant to the laws of intestacy, which you might not want because you might have wanted to give it to somebody specifically. So another common mistake is not appointing an executor, or there's not enough specific details as it relates to the item being given. So my land in St. Catherine, what land? Where in St. Catherine? So persons need to be as specific as possible. The address, the volume and folio number, if it is a registered property, if it is a car, you want to identify the car. So that sort of a thing is commonly made. Also not dating the will. No, not dating does not invalidate the will, but it can raise challenge if it is that another will should present itself, which will was first in time. So those are the issues for consideration as it relates to common errors that we might see.
Okay, thank you very much. Mrs. Brooks Hilton, insurance comes when we talk about estate planning, proper estate planning. What are some insurance products that can be used in estate planning and how effective are they?
Thank you for that question, Nadine. Well, in insurance companies, we do have a variety of products. Mostly, insurance companies use their whole life products, their term life products, and their investment life products because it's a contract between an insured and the company, and it comes with specific instructions such as beneficiaries.
Fancy words. Whole life products?
Yes.
Second one?
Term life products and investment life.
Tell us a bit about those.
First, let us go with ordinary life, which is whole life. That is a product that you can have up to age 100. On the ordinary life, which is the whole life, you would also have an investment portion if you so desire to add that. So you can benefit from that product throughout your life. Then you have term life. People use it because it's relatively inexpensive. So you may have your children and you cannot afford to pay for the whole life. But term life gives you a specific time, like a 5-year, a 10-year, a 20-year, a 30-year. Or you can even have term for life because it's relatively inexpensive than the ordinary life. So most time people are buying...
So what do these products do? Like upon death, you show the instrument and what happens?
Well, as I was about to say, the term life, most time people will buy it because they are looking mortgage. No, they can use it as collateral security.
Okay.
Outside of that, upon death, whoever is named as the beneficiary or if it is assigned to an institution upon death, the contract is bind to whosoever is left. So if it is for your beneficiaries and you have your named beneficiaries, for example, Nadine should get 100% of this, then upon that time, Nadine comes into the insurance company and she is the person the insurance company speak to. If it is an assigned policy for mortgage purpose and you have that assigned, then the assignee company will speak to the insurance company and then they pay out to the insurance company. If the loan was being paid down, the balance that is now left, for example, it was at 10 million and you paid out 5, there's 5 million, then this is when the beneficiary would come in.
How easy it is for beneficiaries to get whatever these policies say they're supposed to get?
It is so easy. it is easy as 1, 2, 3, as long as you honor your contract. So the first thing is that we ensure, the insurance companies tell you, we will honor your claim once you honor your contract by paying your premiums up to date. So the policy has to be enforced. Now, upon death, we ask that you come in with the requisite information that the insurance company asks for. The first one is the contract. So we need that contract. Then we would need the death certificate or the medical certificate. We need the requisite identification, sometimes birth certificate, the ID, your TRN, stuff such as that. But the most important thing is the contract, the death certificate, and your requisite identifications.
Okay. Mrs. Leith Palmer, I'm sure insurance policies would also be a part of your will.
No, insurance policies are not normally part of the will, because if it is that you have indicated a beneficiary,
Yes.
then the insurance company will deal with that beneficiary.
Okay.
However, if it is a situation where you have not named a beneficiary and you want it to fall to your estate, then you can indicate that on the insurance contract with the company, whoever it is, and then you can include it in your will. Oftentimes, however, persons would have named a beneficiary as to who the policy is to go to upon the person's death.
If the insurance policy is done for mortgage purposes and you collect the house as an asset, what's the next step?
So normally what would happen is, once you would have collected that particular asset and there is a mortgage outstanding, you will first inquire of the institution, was there an insurance policy in place for this mortgage? Because most times there is. And then upon them indicating to us now what is the arrangement between themselves and the insurance company and the deceased, then that will give us information now to communicate with the insurance company or the mortgage company so that we can recover the benefit of that insurance policy.
Okay. Mrs. Brooks Hilton, what is the procedure for claiming benefits upon death?
So upon death, we ask that the beneficiary or beneficiaries come into the insurance company. And as I said before, they will carry the contract. We normally check to see that the policy is in force. That is extremely important. Now, upon seeing that the policy is in force, we speak to beneficiaries separately because we don't want crowding, and insurance is confidential. So we will sit with you and empathize and then walk you through the process. Now, it depends on the type of death, because there are different types of death. There are accidental death, there's murder, there's just normal death. You know, you're sick and you die. Sometimes the death is caused from maybe a critical illness, such as cancer, heart attack, or stroke. So sometimes we do need an autopsy report, depending on the type of death. But outside of that, that is where the medical certificate or the death certificate comes into play to say this is what the person died from. If it is a murder case, then you know the police is going to come into play because we need police report. If it is murder, that goes to legal because it is a legal thing now, depending on the surroundings and the situation. Outside of that, claims are payable within 48 hours, depending on your contract. We try, because insurance is redeemable for cash upon death, whereas with the estate, you have to maybe probate and all of that. We don't want people to wait. We want them to know that this is necessary, and that is why you made a contract in the first place, because we have to honor final expenses. And you don't want to keep nobody body for they say that insurance take long. So we encourage people, along with their will, to make sure they buy life insurance, because it's the first form of payout.
Okay. Mrs. Leith Palmer,
Yes.
earlier you spoke about a trust in terms of estate planning. What is a trust, and how does one make a trust?
Well, a trust is a formal transfer of assets from the grantor, that's the person making the trust, to one or two, normally two or more persons, or a trust company, for the purpose of the trust company or the trustee to hold that asset or those assets for the benefit of the beneficiary. The trust is an important vehicle in estate planning, but it all depends on what it is you want to get out of it. So if it is that you are, let's say, for example, trying to protect your relatives, so you have a young child and you want to ensure that he or she is taken care of until they get married or until they become an adult, then you can create a trust, which will, with instructions for the trustee to make allotments or payments for the benefit of this beneficiary over a period of time. The trust is very specific. The instructions contained therein, the trustee is required to honor it. The trust can be a testamentary trust or a life trust, inter vivos trust. So the testamentary trust, however, you'd have to wait until the probate is completed because it forms a part of the will. If it is an inter vivos trust, then it takes place once you have executed the deed of trust.
Okay, thank you very much, Mrs. Leith Palmer. Any final words before we go?
Just to encourage persons the importance of estate planning. And don't think that just because you've made a will or because you're looking into taking care of your assets after you go that you're going to die as soon as you sign the document. It is important because you want to ensure that those who you love are taken care of and there are no issues after you're gone.
Thank you. Mrs. Brooks Hilton, final words from you before we go?
Insurance are beautiful products. And when you have life insurance in place, you have peace of mind. I am saying to families, make a friend, which is the life insurance company, before you need a friend, so that your family can be financially capable or secure when the time comes. Not only that, now a lot of people don't realize that there are living benefits for insurance, such as trying to acquire a mortgage. You have to, most companies ask you for the life insurance product to secure a mortgage. And a lot of people don't realize that critical illness, it is so important to put security in place for critical illness because it is instant cash you're getting while you're alive. So it is extremely, I can't emphasize that anymore, to have life insurance.
Thank you very much. Thank you, ladies. And that brings us to the end of this segment of the Administrator General and you. Thank you for watching.